The Honorable Judge Porter is presiding. Court is now in session.
All right, court is officially in session, and anytime a judge opens with
Judge sets the tone. When a judge comments on someone's condition before the case even starts, it signals concern and possibly skepticism. In court, first impressions quietly shape everything that follows.
"You don't look too good." You already know this case is about to go off the rails. This is small claims court, but don't let the setting fool you. Big consequences can still happen here.
Good morning, everyone. Please be seated. Thank you so much. We're here for case number 3696, Brianna Hayes versus Brandon Yates. If you can please come to the podium. Ms. Hayes, good morning.
Good morning.
You don't look too good. You okay?
No.
Okay.
My neck is nearly broken.
I see that.
Okay.
We're going to get to that. Good morning, Mr. Yates. How are you doing today, sir?
Hello, how are you, Your Honor?
Okay. Ms. Hayes, it says here that you're suing Mr. Yates for $7,500 for pain and suffering and emotional distress. Am I reading this correctly?
Correct.
Okay. Tell us what happened.
A few weeks ago, I had slept on my couch. I'd fallen asleep watching TV. And I think maybe like the arm of the couch may have, had an impact on my neck. And so I thought I'd call up my local, chiropractor. And I set an appointment, just let him know about the crook in my neck. And then I think he broke something. After he twisted my neck, everything just kind of changed a bit. I walk slow, my lower back hurts. I have some sort of cervical problem, and it's taking a toll on my life.
How do you know that you have a cervical problem, ma'am?
Because, like I said, it's like a domino effect in the rest of my body.
Okay. Did you go to a doctor, another doctor, the hospital?
Shortly after, a few hours after the intense pain after his appointment, I went to urgent care, and they said that I probably broke.
This is a major courtroom issue. She believes something is broken, but belief isn't evidence. Courts don't run on pain alone. They run on documentation. No scans, no reports, no diagnosis puts her case on thin ice.
Something. I fractured something, a vertebrae. I don't know. I just know that.
Here's the first legal red flag. Notice what she's saying. No diagnosis, no medical report in hand. Just pain, pain, and more pain. In court, pain is real, but proof is king. Judges immediately start asking, where's the documentation?
It's not fair, and it has ruined my life. So
wow.
I deserve proper compensation.
Okay. How long ago did you go see Mr. Yates?
Maybe 6 or 7 weeks ago.
Okay. Now, when you went to go visit his practice, I'm assuming he did adjustments with his hands and things of that nature. To your recollection, did he do anything like a CAT scan or an X-ray prior to any of this?
No. It was
Did you have to sign any documentation prior to this?
Barely. I didn't think it was gonna happen like this. He told me that he could fix it. He made me sign some sort of...
Yes, the infamous waiver. Everyone signs them, nobody reads them. But here's the twist. Waivers don't magically protect professionals from...
Here's where many people get confused about waivers. Signing one doesn't give professionals a free pass. If negligence is involved, waivers lose their power fast. That's why the judge is listening very carefully here.
Negligence. If the provider cuts corners, that paper shield gets real flimsy, real fast.
waiver, but it wasn't really specific, so.
Okay. Mr. Yates, good morning, sir.
Good morning,
You
sir.
heard what she had to say. Are you a licensed chiropractor, sir?
I am, sir, for 9
So
years.
the state of Florida has said that you're good to go.
Yes, for 9 years now, sir.
Okay, and Mango Park has said that you're allowed to. They gave you a business license to work within the city limits.
Yeah, I'm
Okay.
I'm around.
How long have you been doing this type of work, sir?
9 years, sir.
9 years. Have you ever had anything like this happen before, where someone has pulled you into court, or maybe they said
No, never court. I've had a few misalignments here and there, but anyone that flinched was coming to see me, I'd be out of work. you know?
Okay. All right. Now she said something about waivers that she had to sign prior to this. Can you explain what's in that waiver?
Yes, Your Honor. Basically, we have a waiver at our office that lists do's and don'ts and lists can'ts and won'ts and lists all the things that you need to have, you know, if they've been in an accident or if they've had problems with their back before, you know. Anyway, so we have a waiver that they fill out, and this woman in question did not have any notes on her waiver that she had misalignment or that she had neck problems or anything. So
do you recall when she came to your office, do you recall why she told you that she was there?
She was complaining of having several neck problems, so I checked her out. I gave her a new alignment. And
okay, now prior to doing your, because I understand in that business, you're not cracking, you're adjusting. Am I correct in
we're
saying
making
that?
adjustants. That's
making
true.
Adjustments.
Allegedly.
Okay. Now prior to that, she says that you guys did not perform any type of x-rays or scans. Is that correct?
That is correct, Your Honor. We
May
don't
I
do that.
ask why?
That's not something that we do at our office.
Wait a minute, you never do x-rays or scans?
Not usually, no, not unless it's necessary.
And there it is. No scans, no x-rays, no imaging.
This is huge. No x-rays, no scans, no imaging, especially when dealing with the spine. From a legal standpoint, that's guesswork, and judges hate guesswork when someone's health is on the line.
In medical-related cases, that's like flying blind and hoping for the best. Judges hate guesswork, especially when someone's spine is involved.
Okay, all right. Well, Mr. Yates, I'm confused. If a person comes into your practice and they're saying I have an issue that needs some type of adjustment, whether it, and let's use her case as an example. She's saying I'm having some type of neck problems.
Right.
And I don't know if she told you this, but she told the courts that she had a crook in her neck. I'm sure that you're familiar with that term, crook in the neck.
Yes.
I'm pretty sure there's a medical
It's a
term behind
layman's
it.
term,
Yeah.
Your Honor.
Okay, but the thing is, here's why I'm a little lost. If are you do you have type of medical training or
Do I have any medical training? No.
No. So anything as far as an injury, you wouldn't be
No, I'm a
comfortable
teacher.
saying, okay.
I wouldn't
Okay,
know.
so she doesn't have the medical information or training to say, okay, I believe the analysis could be boom, 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 and you do.
Right.
But here's where I'm lost at. If she says that she has a crook in the neck, okay, and as you put it, it's a layman's term.
Yeah.
Isn't it a possibility that her crook in the neck could be a series of other things that led up to this particular? I mean, it's not just one. Yeah, she's complaining of one symptom, but the symptom can be caused by a variety of different issues. Am I correct in saying that, sir?
Wow. Oh, okay.
Well,
That would be a yes or no question, sir.
He knows more about chiropractic? Okay.
Ma'am.
Okay. Ow.
You know, it could be an underlying issue, but usually when we're there, we decide not to look into underlying issues. We treat the immediate problem first, and then if there's a problem, they come back to us and we check their insurance, and then, you know, we proceed with more treatment. But
So
Imposter.
hold on, ma'am, Miss Hayes.
This is my fault.
Miss
This
Hayes,
is my fault.
Miss Hayes, I'm gonna need you to calm those outbursts down. Can you do that for me?
I
this
can
is
try.
highly uncalled for.
Okay. I want to make sure I just heard what you said. So you treat the initial issue, right?
Correct.
And then you wait to see what type of insurance they have and what type of coverage they have, and then you go explore the other possible options based on their insurance.
Well, that's a part of it, but you know, really what we need to do is assess each case differently.
Okay, all right, Mr. Yates, you say you've been doing this for 9 years?
Yeah, almost 10, you know.
Almost
Allegedly.
10. Congratulations on almost reaching 10.
well, you know.
I know running a business is not easy.
Yeah, no,
But here's where I'm
chiropractic
confused.
is a hard
Here's where I'm
business.
confused at. It sounds to me like what you're saying is, well, we're not going to do what's necessary until we make sure we're going to get paid.
This is the moment the case cracks, no pun intended. The judge just translated
This is the turning point. The judge just translated professional language into plain English. Treatment decisions appeared tied to payment, not safety. Once a judge frames it that way, the case usually starts collapsing fast.
chiropractor speak into plain. You didn't investigate until you knew you'd get paid. And that, folks, sounds a lot like negligence.
That's what it sounds like. And I do understand. I understand that you're running a business. I got that. I understand that. But it sounds like you're taking some shortcuts until you can guarantee that you're going to get paid.
Busted.
No, that's
Miss Yates,
Ow.
that's what you get.
that's right, Your Honor. Good for you.
So, Mr. Yates, explain to me why you don't have a system in place where you can do a scan, where you can do an x-ray, because although it's a crook in the neck, it may be some other underlying issues. Would I be correct in saying that?
Well, you know, it's a slippery slope. And basically, we work to the client's best interest always.
No, it sounds like you're working to your best interest right now.
Hello.
That's what it sounds like.
Well, that's one way of looking at it.
No, that's the only way I'm looking at it. I'm trying to understand why that is. Because if you don't have a system in place where you can do an analysis prior to doing the adjustment, you're doing an adjustment based on a guess. You're not doing an adjustment based on, well, we did the scan, we see this. We did the x-ray, we see this. What's your medical history? Okay, it could be this. There are all these factors that should come into play prior to you doing an adjustment. And it appears that you didn't do that. You were like, oh, a crook in the neck, don't worry, we're just gonna do a quick little adjustment and send you away and we'll see what happens. And in the meantime, what's your insurance policy number?
Wow.
Well, that's not the way that I see it, but
What is the way you see it?
I see that we're providing a service for people that helps them and they come back to us. And
I see that you're providing a service for Brandon Yates. That's what I see. That's what I see. And that's why that lady is in that brace right now.
Notice how the judge isn't debating chiropractic as a profession. He's focused on process, due diligence, assessment, follow-up. Courts don't punish accidents. They punish shortcuts.
Because you did not issue due diligence prior to giving her care. You just said, you know what? Oh, I know what this is. Crack, 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 crack. And then you sent her on her way. Did you when she started, did you advise him that you were in pain afterwards?
Yes, afterwards it was immediate, intense, excruciating pain.
Okay.
And it didn't seem to matter.
that always takes place.
I'm talking.
She's
I'm
talking.
talking.
She is talking. She has the floor.
I pray that your pockets end up like your chiropractic practice, just broken and tore up. How dare you? Oh my God. Yes, so immediately after I had a lot of pain, and I was telling him like, hey, this hurts. Like on a scale of 1 to 10, we're at like a 9.5. Like, how do you make this stop? He assured me like with some aspirin or something that it will go away. This was maybe like, I don't know, 4 p.m. And I had my husband take me to the hospital. Like, there is no way that this is gonna continue like this. It was excruciating pain. It hurt to drive. It hurt to walk. It hurt to sit. It hurt to lay down. I'm just in constant pain for hours. And it just ruined my life, and it's not fair.
Okay. And you said this was a few weeks ago?
Yes.
You haven't gone to work? Do you work? You
yes.
said you're a teacher.
I'm a teacher, correct.
And I'm assuming you have not gone to class.
I'm sorry?
I'm assuming you haven't been able to go to class.
No, not really. I tried, but then they sent me back home.
Are you losing pay, or do you already have sick leave?
I have some savings, but I have nothing coming in.
All right.
Your Honor, if I may interject here for just 1 second, there's always a little bit of discomfort and a little bit of an adjustment each time we do.
To the point where they end up in a neck brace?
That is a little
Let me ask you, did you have a contingency plan for a follow-up in case something like this were to happen?
She didn't schedule one, so we...
Wow.
Did she call you and tell you I'm in pain?
I'd have to check with my
Oh,
secretary.
now you have to check your messages. This guy is insane. I'm sorry.
Okay. All right. Okay. You know what, Mr. Yates, I have to be honest. I'm a little bit concerned about the things that I've heard here today. And I'm not a businessman. I'm not into the medical field, so there are certain opinions that I don't think would be proper for me to say under these circumstances. But what I am going to do is I am going to have the state's medical board look into your business practices, because what I heard today, it sounds a little bit shady to me. Shady, yes, shady. And as far as Mrs. Hayes, I understand what you're going through, and I'm sorry that you had to go through this. And I feel that there is some, how do I say this, dismay over on this part where this gentleman, his business doesn't seem to really care about their patients, or at least you in this case. So, but unfortunately, the 7,500, I can't do 7,500. I'm sorry, ma'am. I don't see 7,500 happening. So I'm going to give you a different amount. I am going to grant you one.
Wait, did you catch that? She sued $4,750 and walked out.
This isn't just about money anymore. When damages jump this high, the court is sending a message, not just to the defendant, but to the entire profession. Accountability, not compensation, becomes the priority.
Out with $100,000. That's not generosity, that's a judicial message. When a judge smells systemic problems, the damages stop being about compensation and start being about accountability.
$100,000.
What?
And I'm sorry.
Nothing?
Oh,
I can double it if you like, if that's too
I
little.
would like. Oh,
No.
Would you like me to add more to that? Because that's what it sounds like. You were just shocked that I gave her only $100,000. Would you like me to double that amount, sir?
No, Your Honor. I would not like you to double
That's
it.
what I thought. That's what I thought. So I'm going to grant you $100,000 for your pain, suffering, and emotional distress. You will be receiving a telephone call from the board sometime this week or next week. Do you have any questions or concerns?
A telephone call about what?
From the board, so they can start their investigation into your practice.
Into my practice? Sir, I am a trained chiropractor, and it's Dr. Yates, not Mr. Yates. I was trained by the highest gurus in Eastern Europe and Kazakhstan, and I studied for 20 years on chiropractic. It's not my fault that this woman is trying to scam everybody out of some money.
I'm a scammer.
Okay.
Wow.
Well, first off, I do apologize for referring to you as Mr. Yates, Dr. Yates.
Well, that's
Doctor
better.
Who?
So,
I'm sorry, Your Honor.
See, she's a scammer. She's scamming.
so we're okay with the $100,000? Yes, Judge Porter. Yeah, that's what I want to hear you say. I'd like for you to address me by my title.
Yes, Judge Porter.
See how that works? And I wish you the best of luck with your business and the investigation that's coming forth. Make sure that you pay this young lady on time. We will be sending you information on how to make that happen. Monthly payments if necessary. Okay, sir?
Yes, sir.
Yes, who?
Yes, Judge Porter.
Okay, Dr. Yates. You have a good day. This case is adjourned.